Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, it's me. Hello, everyone. This is Pam Esquire, also known as your law intellect. Hope you guys had a great rest of your day. We did talk earlier. We talked about Jake's earlier and the case against Dwayne Youngblood, of which there were some sanctions. It was a lot of drama over there in that case. So if you guys have not seen today's video, make sure when we finish with this one, you go over there and hit that like button on that video. And if you have not subscribed to this channel, make sure you do so. But wait till this is over because we need you all in this chat for this next episode. Okay. Many of you guys were with me as we watched for a few days, for hours, the Cardi B trial. And what Cardi B was accused of is assaulting a security guard when she was pregnant with her first child back in, I think it was 2018, when she went to try to be private and go to have a doctor's appointment in California. It was not her normal doctor because she doesn't live there. Okay. I think she may have a home there, but she does not live there. And so she asked a friend, "Hey, do you know I'm feeling kind of funny?" She hadn't even told anyone that she was pregnant because, she likes to tell you on her own terms, as we see. And so someone had given her an option to go to this specific doctor, and she was gonna be the last patient. I believe it was on a Saturday. So no one else, no other businesses were in the building, plus she would be the last patient. This doctor sees celebrities regularly. And she goes in there, and apparently there was a lady her name is Emani Ellis. And she was the security guard, and apparently she was a Cardi B fan. And so, according to Cardi B, she immediately started taking out her phone, trying to record her. And in Cardi style, she was like, "Well, what are you doing? Why you recording me? What's wrong with you? Why don't you go do your little cop job and go protect the building? What you following me for? Put the camera down on your phone." And she said the lady was like, "My bad." And then they get into this altercation. And according to Miss Ellis, she was alleging, and she sued Cardi B for money. She alleged there was a physical altercation, where she said that Cardi B attacked her and she had a permanent scar that needed some micro needling, and it was thousands of dollars in a bill from this plastic surgeon. And ultimately, wah, wah, wah. Miss Ellis lost. And even when she did the press conference after the loss, they alleged they were going to appeal. I don't know what they're appealing for, but hey, it's optional if you choose to do so. But what was interesting is that during this case, there were a lot of issues that occurred. So Cardi's attorneys were objecting a lot throughout the trial, and some of the objections were excuse me, because there were, prior to trial, we have motion day, typically about a week before trial, and they're called motions, where we turn in motion and limines. With motion and limines, it's because we want to exclude certain evidence. In some instances, they try to admit some evidence. However, it's more commonly known that you use it to exclude evidence. Some of that evidence that the court had already ruled on, apparently, Miss Ellis's attorney felt like that he was what order? Who, me? What order are we talking about? I'ma still ask the question. And so there were a few times where you heard Cardi B's attorney stand up and say, Your Honor, objection, motion in limine. And one of those questions, if you all recall, was about Cardi B's affiliation with GANGS's. Okay. And a motion in limine was granted that he could not bring it up. And probably within the first, I think it was what, the second day of the trial or something, within the first few questions, he asked about it. And so Cardi's attorney, because of all of the alleged misconduct, they were saying that they requested the judge to allow them to do an order to show cause why he shouldn't be held in contempt or be held to be sanctioned for this behavior. And one of the things people were talking about, they were like, well, how long has he been practicing? And I looked them up when we were online and I was like, he is not new to this. He had been practicing for at least 20 years, according to the California bar. And so now Cardi B's attorney said it's not over. Even though they won, that's just not enough. They want everything that they are entitled to, and they are definitely going to pursue whatever remedy that they can get for the alleged behavior that they are arguing occurred during that trial with Miss Emani Ellis's lawyer. So they're basically saying you lost. You had to pay a doctor to come per hour, because what happens is when we take these type of cases, we usually take them on contingency, meaning we anticipate that you're going to get some type of a settlement if it goes to that length, or it go to verdict and we get paid at the end. So that's why when you hear the billboard say, we don't take any money until you win, that's just basically we're taking it on contingency because we believe in your case and we believe that we're going to be able to get our money. So it's like a gamble when we take it on, but we believe we're going to get it back because we believe that there's a legitimate and viable cause of action and that there are legitimate and viable damages, and we're going to eventually recoup our money. Well, in this case, obviously that bet did not work for Miss Ellis and her lawyers because she lost. Well, now again, Cardi's team has filed the necessary motion in order to perhaps have a hearing on whether he should be ordered to show cause. All right. So that's the document that we are going to go over. You guys with me? That was a good little quick intro. It took about 8 minutes. Thank you, Kimberly, for becoming a member. I appreciate that. We also do have a goal. Okay. I think we do. Don't we have a goal? If we have a goal, please make sure we reach it, you know. Seahawk, thank you so much for gifting 5 memberships. I appreciate the support to the platform. And yes, if you don't have the ability to give the super chats, because that is a monetary donation to the platform, if you hit the like button so that other people know that we're here and that we can be a part of the algorithm, but also super chats are make you a part of the algorithm too. That's why I started doing those goals as well, because it does, help you out a little bit. I guess YouTube said you make me money. We'll suggest you. I don't know. But it seems to put you like in that algorithm where you'll be suggested from people that have never been to the platform. And yeah, and also I don't know if the likes affect whether people get notifications or not. We talked about notifications before. According to my analytics, only about 5% get notifications. I don't know who is the lucky 5%, but that's roughly about 1,000 of you guys might get notifications, roughly, according to our number of subscribers. So That's right. Detroit 313 in the house. That's in the building. Tyrone said he wanted the smoke for this dumb case. Now he got it. Well, you might be right, Tyrone. All right, so let's see. Let me find this. You know, I have so many cases on. So many cases. Let's find Cardi B's. And so this is what was filed. This is Superior Court. This is the Emani Ellis versus Belcalis Almazar, aka Cardi B. This is the application for issuance of an order to show cause. And this was filed by Miss Cardi B. All right. We'll get into the introduction because, again, it will probably highlight some of the things that I have already talked about already. Hold on. Give me one moment. So let's get into the introduction. Defendant Cardi B respectfully submits this memorandum in support of her application for an order to show cause directing plaintiff's counsel Ron A. Rosen Jamfasa Esquire to explain to the court why he should not be sanctioned and or held in contempt for disregarding this court's rulings and for his trial misconduct. Mr. Rosen Jamfasa's misconduct includes unilaterally submitting on the first day of trial a witness list that included a plaintiff's expert the court had already excluded pursuant to one of Ms. Almazar's motions in limine. Not to be deterred, Mr. Rosen Jamfaza, I'm probably jacking his name up with, so I apologize, sir, then repeatedly loaded his witness questions to include references to that excluded expert and his supposed treatment of plaintiff. Also, despite the court's ruling on another of Cardi B's motion in limine that any gang associations were irrelevant and that the jury hearing questions about gang associations would be unduly prejudicial and likely to confuse the jury, Mr. Rosen began his direct examination of Cardi B by asking if she is associated with a gang. In addition, despite the court's admonition not to argue in closing facts that were not in evidence, Mr. Rosen proceeded to do just that, while also violating other rules applicable to closing arguments. Indeed, the record reflects that in less than an hour, Mr. Rosen's closing argument, the court sustained 18 defense objections, or roughly an objection sustained every 3 minutes. Mr. Rosen misconduct was not isolated. It was no isolated slip, and he is no novice, having practiced for over 20 years. And they have the footnote that shows the State Bar's website states he was admitted to practice in November 2004. Instead, his misconduct was part and parcel of his trial-long pattern of disregarding and trying to undercut the court's orders, culminating in his disregard and established rules governing closing argument. His willful disobedience of lawful orders and defiance of the court's admonitions led the defense to raise on the last day of trial that Mr. Rosen's misconduct merited sanctions and citations for contempt. The court responded by allowing Cardi B to request an order to show cause directed to Mr. Rosen. Her application should be granted, and an order to show cause issued directing Mr. Rosen to establish why he should not be sanctioned and or held in contempt for his trial misconduct. I think what happened a lot during the trial too, while the judge said, "Can we handle this after the fact?" I think the judge was just trying to get through it and was like, you can preserve and reserve your right to bring it up, and that's what he is doing right now. Hold on. An order should issue directing plaintiff's counsel to show cause why he should not be sanctioned for trial misconduct. So then they go over the law, how California authorizes the court to issue an order to show cause where counsel has willfully disobeyed a lawful order. The elements of contempt are: one, there has to be a valid order. Okay. There has to be a valid order. Two, knowledge of the order. Three, the ability to comply. Four, willful failure to comply. So those are the elements in order to for the court to authorize the court to issue an order to show cause. So if you see any of that in here, so they're going to go through and show how this has been proven on why order to show cause should be issued. In addition, Code of Civil Procedure Section 177.5 separately provides that courts have the power to impose reasonable money sanctions not to exceed $1,500, notwithstanding any other provisions of law payable to the court for any violation of a lawful court order by a person done without good cause or substantial justification. Also, trial courts also possess inherent power to impose sanctions, including for trial misconduct and violation of orders in limine. So, the first argument is there was a violation of the court's in limine order. The court's in limine order excluding reference, argument, or evidence regarding prior gang affiliation. On July 1st, 2025, Ms. Almanzar filed motions in limine, including her MIL number 1, for an order barring plaintiff and her counsel, quote, from referring to, arguing, or introducing any evidence at trial regarding defendant's past as an exotic dancer or any former association with a gang or gang members during her youth. So that's their motion in limine 1 and 2. So that's what the order said. All right. In granting the MIL, which is motion in limine, on July 30th, 2025, they got 3025. We ain't there yet. You know what? Little typo, little slip of the keyboard. The court concluded that defendants' prior acts and alleged prior acts, as well as any gang association, have no apparent probative value, and any reference thereto would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. So basically, what some people will do, and they try to probably do it in this case, especially if she's being accused of assault, it's kind of like they did it before, so they probably doing it again. If they have a history of this, we want to use that to try to show almost like a pattern of doing the same thing. Now, in criminal cases, oftentimes, like what was happening with Diddy, that's what he was fighting a lot of. They'll use it as like MO. There are exceptions to those rules of other like bad conduct, prior conduct, or prior acts. And so, but the problem with that is oftentimes, of course, most of the evidence against your client is prejudicial, but there is some that is way more prejudicial than probative. Like it has really not much merit on the case. but to prejudice you and make the jury side eye you a little bit, like, oh, okay, that's what you was doing. You was out here on the corners beating up people, type thing. So the judge did come to the conclusion that it should not be admitted in this case. And so on the second day of trial, however, Mr. Rosen called Cardi B as a witness in plaintiff's case in chief, and one of his very first questions was, question, do you have any affiliation at the time with a gang? And then Mr. Anderson got up, objection, Your Honor, motion in limine, that violates the motion in limine, the order. And the court says, sustain, counsel, you know better. You know better. And we heard that when we watched the trial. So Mr. Rosen has argued that he did not violate the court's order because he asked Cardi B whether she is affiliated with the gang, not whether she used to be. So he's trying to say, well, I didn't ask her if she was in the past, because the motion in limine basically says that you're not supposed to bring up past conduct. I was trying to see if she affiliated right now. Try to find a little, backdoor way to bring in what was already excluded. However, the only conceivable basis to ask that question, and implicit in that question, which the jury heard, was that she used to be associated with the gang. That Mr. Rosen referred indirectly to her past does not change that he referred to it. He also knew that the court, in granting Cardi B's motion in limine number 1, had included, quote, that any gang associations have no apparent probative value and any references thereto would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. And that was July 30th of 2025. As a result, Mr. Rosen knew he was asking a question that the court had ruled was irrelevant, prejudicial, likely to confuse the jury, and properly forbidden. Despite actual notice of the court's ruling on Cardi B, motion in limine number 1, and the court's conclusion that references to any gang association was improper and not to be asked in the jury's presence, Mr. Rosen did just that he was willing to risk the consequences of his obvious attempt to prejudice the jury only lends further support to the issuance of an order to show cause. Otherwise, he will continue to treat courts as sparring partners rather than tribunals whose orders and rules he is required to obey. So they're saying he might need, a little deterrence here from doing this ever again. Then there was another in limine order striking Dr. Avila and barring his testimony. On July 1st, 2025, Cardi B also filed her motion in limine, which was number 3, for an order striking Mr. Rosen's attempt to unilaterally add a previously undisclosed expert, Dr. Alex Avila, and barring testimony from Dr. Avila. And that was granted on July 30th, 2024. Yet, the morning of the first day of trial, Mr. Rosen intentionally tried to slip Dr. Avila into the case by submitting to the court Mr. Rosen's own unilateral witness list, falsely labeled joint, that included Dr. Avila. So, according to Cardi B, what he tried to do was, let me go ahead and turn in this witness list, and I'm gonna mark joint like they okay with this witness, this expert witness who was already supposed to be excluded based on the in limine. And I'm gonna try to slip them in there right before trial starts. Thank you so much. Gotta love Jones for the super chat. I appreciate it. So yeah. That's what they said happened, that he tried to slip that document over and say, this is a joint witness list, like they're agreeing to it. But Cardi B, they were looking at that witness list and they were like, oh no, he's not supposed to be on here. Further, facing the fact that due to his own failure to timely move to argument, let me say that again. Further, facing the fact that due to his own failure to timely move to augment his expert disclosures, He had no psychologist to provide expert testimony. Mr. Rosen asked multiple witnesses questions in which he included his own references to Dr. Avila and Dr. Avila's purported treatment of plaintiff. So because he wasn't able to have an expert psychologist, what we saw on the stand was he was trying to elicit some type of like this doctor's testimony through other people to kind of find a way to get it in. Mr. Rosen, improper reference to Dr. Avila constitutes contempt. He had actual notice and knowledge of the ruling excluding Dr. Avila, and the court raised that ruling at the outset of trial when Mr. Rosen brazenly included the already barred doctor in plaintiff's revised witness list. Mr. Rosen could have complied with the court's order by simply not mentioning Dr. Avila, but desperate that he had no psychologist expert, he chose instead to violate the court's order by bringing an excluded expert in by the back door using loaded questions. So, thank you, Sheriff, for the super chat. I appreciate the support. And so, the struggle bus, the whole case was a struggle bus because the damages were so minute that I told you all before that there are times where a person is obviously liable. Say, for instance, you're driving in a car and somebody hits you from behind. There's a presumption that they are liable. Rebuttable, but for the most part, you're liable because what you really defending that, unless it's some type of medical emergency, there's certain exceptions. But if you are not injured or there's no damage to your vehicle or there's nothing to sue for, you still can't sue. And my issue with this case was, and we showed the picture, my issue with this case was that there just seemed to be minimal damages. So they probably relied a lot on psychological damage. This is the damage that she had right here. And so this is when she went, I guess, to get this micro needling. And she alleges that Cardi B's fingernail scratched her face. And this was considered like plastic surgery by getting this micro needling. And this was her damages. Outside of this, her attorney had to basically argue that you couldn't hardly see it, because of course she had makeup on. So that he pointed out she had lipstick on. So you couldn't hardly see it when you took the picture before you provided the services to her. And he had to keep trying to make the jury think that this was some deep, I guess, scar in order to conjure up these damages. And part of her damages would have been psychological because her mother and her grandma was so sweet. They got on the stand and they were saying, listen, she was so depressed. She was so depressed when all this happened, and she was a fan of Cardi B. And this just devastated her, and she went into these states. So they were trying to get, I guess, someone to confirm and corroborate this. And you need, an expert or someone to say that, a doctor, a psychologist, somebody. And they didn't have it. So what Cardi B's lawyers are clocking is, because you didn't have the witnesses to support your damages. Because again, when it came to liability, that was he said, she said. Miss Ellis said she hit me. Cardi B said I did not. So that was he said, she said. So it was going to be about the credibility on liability. But when it came to damages, you have to prove some type of damages. And so I think what they are alleging in this document is she wasn't they were struggling. They were on the struggle bus because they didn't have any psychologists to support their position that she had these psychological issues and she needed therapy. And these were the repercussions, these were the results of Cardi B allegedly doing this. And your expert was struck and you really didn't have anybody. So what you were trying to do was to use other people to get it in, which was improper. So that's what they're saying. Jam said, I believe mom tried to sympathy tamper with the witness. I don't know. I know allegedly there was some conversation, but that the I know the juror, there was supposed to be some conversation, but they both said that they didn't talk and they didn't talk about the case. Even if they did speak, they didn't talk about the case. So let's move on with this document. Make sure you all have hit that like button. Thank you. Mr. Rosen gang question was a trial misconduct for an additional independent reason. Independent of his violation of the court's ruling on Cardi B's MIL number one, it was trial misconduct for Mr. Rosen to ask her if she is associated with the gang. Of course, no evidence was adduced in discovery or at trial that would provide Mr. Rosen with a good faith basis to ask such a prejudicial question at trial and in the jury's presence. Asking the question was misconduct, and they have the case law that basically provides, so this is Hawk v. Superior Court, a lawyer shall not state or allude to any matter that he has no reasonable basis to believe is relevant to the case or that will not be supported by admissible evidence, affirming contempt finding. And they have other cases as well. They also have thrown in the American Bar Association Model Rules of Professional Conduct Rule 3.4E that counsel shall not in trial allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. Nor did Mr. Rosen advise the court or defense counsel beforehand that he intended to ask Cardi B about gang affiliation or provide an offer of proof as to a good faith basis to ask the question. Instead, he sought to prejudice the jury by a baseless question on a subject the court already ruled was irrelevant, unduly prejudicial, and likely confused the jury. That also is trial misconduct, warranting the issuance of an order to show cause. Now they're getting into his improper closing argument. Despite prior admonitions from the court and some 18 sustained objections in the course of his closing argument of less than an hour, Mr. Rosen made a panoply of improper statements in closing. They include, but are not limited to, arguing facts not into evidence, misrepresenting the trial testimony, and personally vouching for his client's testimony. So you're not supposed to argue facts that are not in the evidence. When you're in closing argument, you can only talk about, you can have your own inference, assertions, what you believe, but even if you infer something, it has to come from the actual evidence that is admitted. You cannot just say things that were not proven one way or another by tangible evidence, witness evidence. You cannot just say whatever you want to say in closing. That is prohibited. You can only basically, your closing argument is to tie the case together by the facts that you heard. Again, if one side said, I'm going to prove this, then my side is going to say, didn't they tell you they were going to prove A, B, C, and D? Cross that out. They didn't prove that. Cross that out. They didn't prove that. On the other side, if I say I'm going to prove something and I told you I was going to prove it, and I'm going to check the boxes every time I show you the evidence that proved it. So you can't argue facts that are not into evidence in your closing. Closing argument is confined to the facts admitted into evidence and reasonable inferences from those facts. Counsel may not allude to matters not supported by admissible evidence or assert personal knowledge of facts at issue. All right. Importantly, before closing argument and after Mr. Rosen stated he intended to argue a fact the court told him was not in evidence, the court expressly directed Mr. Rosen that he could not argue facts not in evidence and that doing so would violate the rules of professional responsibility. So this is the conversation. Mr. Anderson said, just briefly, because remember, he was all mild-mannered and smooth. Just briefly, a couple of questions. First, as if you remember, counsel violated a motion in limine order. And now he's talking about arguing things that are not in evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that at least let me say, if the court doesn't want to tell him that he has to follow the rules, he can't argue to things that aren't in evidence, he can't violate the motion in limine. And the court cut him off. I think it's readily apparent that you can't argue facts that aren't in evidence, and the plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed. So he's like, listen, I think counsel knows better. So if he chooses to do it and you have to object, then it is what it is. He knows what his professional responsibility is. Then the court said, all right, anything else from plaintiff's counsel? And Mr. Rosen said, yes, Your Honor, I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence. The court said, I think you just said you were going to. Like, what do you mean you'll never do it? You just said you planned on it, sir. Despite the court's instruction not to argue facts not in evidence, he did so anyway. In closing, Mr. Rosen repeatedly asserted facts outside the evidentiary record, despite the court's warning and multiple sustained objections. Mr. Rosen's repeated misconduct was serious enough that the court cautioned the jury that they should disregard his arguments that were not supported by the evidence. Each of Mr. Rosen's assertion of, quote, facts outside the record violated the court's on record directions controlling case law and the rules of professional conduct. This misconduct also is more than sufficient to justify the court's issuance of an order to show cause. So basically, they're giving you a whole lot of reasons for this order to show cause. Deb said, yo, brother, judge don't like you, but no, the judge was, he was like, you know better than that. It was a few times judge was like, is this moot court? Is this like a mock trial or something? Like, is this mock trial? Is this trial skills in law school? Because what are we doing here? Yeah. It was looking amateurish, but I think honestly he was just kind of grasping for straws because he did not have the evidence to support his claim. Like everybody would just have to believe his client, and that's it. Like the jurors would just have to believe his client and how the client's rendition of everything that occurred and the client's damages. You would have to believe everything that they say. It has to be just total credibility because they really didn't have any experts to support it like that. I mean, they did have the plastic surgeon, but I don't know if that was more helpful than hurtful because it was like he got on the stand and said, well, I charge this much for the micro needling and it's called surgery because you have to go to a surgical facility because it involves blood or invasiveness. So that's what it is, even though when you look it up, it's kind of a minor technique. And he charges thousands of dollars for, charges whatever amount for the procedure. Then just for the room itself, to rent the room for it to happen, it was like 6,000-7,000 or something like that. Then he said he undercharged himself. Then he said she might need to come back. So yeah. Jam said judge was giving him refresher homework. Yes, it was definitely, that's not the time to cut your teeth. Is there going to be times where you cut your teeth? Yeah. There were a couple trials that I was embarrassed, but they were in our smaller courts. They were like in our district courts. The amount was $10,000. Like it wasn't really that major. But when you starting to get on a case that is high profile, that it's going to be televised. I'm going to need you to be on your P's and your Q's. You should have been studying the rules of evidence just in case. Going over all those rules because that will forever be on the internet. All those clips, you getting admonished in front of the world. I can't see that really helping it's not great marketing for your career. That's all I'm saying. But do you make mistakes? Yeah. I remember when I first started out doing like criminal and standing in front of judges and them using terminology that I didn't know what the heck it meant, because when I went to law school, we started learning plain English. They wanted to get away from using all the Latin terms and all of that. So there were certain Latin terms we learned in school, but of course pro hot because they still use it. But there were certain, they tried to get us to a point where we want the world to know how the legal system works, instead of it being like some foreign object, like we're speaking a whole different language. So when they would get like judges that had like guest high school classes in, I had that happen one time. Oh, they get real professional and they'll say things, they'll start using terminology because that's typically, I guess, what they did when you started. And I was like, what? Nobody's ever asked me that question before. So it happens. You're gonna learn. But this was the wrong. This guy, according to them and according to the bar, has been practicing since 2004. So he has a 20-year. He's had a been a lawyer. I don't know if he's been practicing. There are some attorneys, some people that pass the bar and they don't practice. So I don't know if he's been practicing for the entire 20 years. If he was doing something else, sometimes you can go work for the city. You can go be somebody's counsel for a board. You can do a bunch of paperwork. You can review contracts. I don't know his history. But according to the bar, he's been a lawyer. He's been barred for 20 years. Now, whether he's been litigating for the entire 20 years is a different question to ask. All right. Number 2, Mr. Rosen's additional misconduct in his closing argument. It also is misconduct to argue matters that were excluded, misstate the evidence, and claim personal knowledge of disputed facts. Arguing facts not in evidence was not Mr. Rosen's only misconduct during closing argument. Closing arguments may not be based on excluded matters, and it has the case law to support it. Yet, in his closing argument, Mr. Rosen argued excluded matter. So it says, by arguing that plaintiff had been seen by Dr. Avila. An attorney also may not misstate evidence. Misquoting evidence in closing is prejudicial misconduct, and they have the case law for that, and they have the court rules for that. But Mr. Rosen brazenly and knowingly misstated the evidence by arguing in closing one, that Cardi B, quote, testified that the photograph of her during the NBA All-Star weekend was taken on the date of the incident. That, yeah, I remember that. And that didn't happen. She didn't say that it happened on the day of the weekend of the incident. She said she was there that weekend and she was still hiding her pregnancy. So she was showing her nails, and she said she had the same nails on when she went to see the doctor. Number 2, that Dr. Fink testified that Cardi B's fingernails had protruding rhinestones the day of the incident. Number 3, that Cardi B was trespassing. And 4, the plaintiff's mother testified that the claimed scar on plaintiff's cheek was a result of the alleged incident with Cardi B. So the mother, I guess the grandmother never said that, or the plaintiff's mother never said that specifically because she wasn't there. And I don't even know if she seen her immediately after it happened. I know she talked to them both, I guess, after it happened, but I don't know if she physically saw them. As far as the trespassing incident, we were all like, wait, what? So they were trying to say because the security guard was in control, she could put people out, and you're supposed to listen to authority. And she told Cardi B to leave, and Cardi B was supposed to leave. So essentially, they tried to sell to the jury that Cardi B was trespassing, because when the security guard, Miss Ellis, got pissed off at Cardi and wanted her to go, told her, get out of my building, she should have left, and told her that's authority and you should have listened to her and left. And I think we all kind of chuckled a little bit, because the doctor said, hey, you go into this office and I'm going to handle this security guard because we've never had this happen before. And she was just acting ridiculous. So the doctor, of course, they were trying to sway it like the doctor just wanted to keep his celebrity roster up. That's why he supported Cardi B. But no, the doctor immediately, without Cardi B asking, went down and complained about her and her behavior and what happened. And so there was no, I don't know if the trespassing was some new argument. I don't know, but it was silly to me. Definitely silly. Further, it is improper for counsel to allude to their personal knowledge of facts and dispute in argument to the jury. So the court rules, professional conduct rule 3.4G says a lawyer shall not in trial assert personal knowledge of facts and issue except when testifying as a witness. Yet in his closing argument, Mr. Rosen alluded to his own personal knowledge of facts at issue by arguing that it would be impossible for a plaintiff to have been talking on the phone and recording Cardi B at the same time because he had tried it himself. The misconduct also supports the issuance of an order to show cause. They didn't get judge. He didn't give you about 5 reasons for an order to show cause. We're nearing the end here. Did you guys hit that like button? 504. I ain't seen you in so long, girl. Where you been? The chat has not been the same without you. 504 said, I guess her back wasn't as security heavy as she thought. And even though this was not anticipated by Cardi B, because she said she really didn't even want to go to this trial actually helped her with her marketing for her album. It did. She was able to take different memes of her, the facial expressions, and she got courtroom edition. And she made special courtroom edition CDs with pictures of her faces during this trial. And she said, I was trying not to come, so I can't believe that it, turned out the way it did. And it did turn out in her favor. And that's why I said, man, when they say all things work together, man, she could definitely use this as support for that. You said Miss Ellis should be suing the lawyer. Well, I don't know. Before him, and I said it before, I figured that she had another lawyer, or that perhaps what came out was that she at least went to other lawyers. The doctor testified that there were a couple of other people that have came and they left cards for their law firms at his doctor's office. So there were other lawyers that, or it sounds like that she may have tried to procure to represent her and it didn't work out. Then it was alleged, I guess, before this guy came on, she did have another lawyer and that lawyer backed out. So I don't know. That lawyer left somehow. I don't know the logistics behind him leaving, but yeah, the wigs. Every day she had a different wig. Then there was actually a converse. I knew the examination of Cardi B by Miss Ellis's attorney, by Mr. Rosen, was going to be wacky when he asked about her hair. I'm like, what does that have to do with the cost of tea in China, sir? What are we talking about right now? So, right. We can't have no lives without you, 504. I don't care if you work and tell them you need a break. So you can't be taking this time away from the platform. But yeah, so the security heavy was Cardi B had a lot of little taglines. She said she was a great witness because she was herself. It wasn't pretending, turning into somebody else on the stand. All of a sudden you're astute and you're grammatically correct. She talked the exact same way. She had everybody laughing at certain times, and she wasn't even trying to be funny. She's like making faces like, what? I mean, she bigger than me. So they were trying to like get her to be mean so people could see that she's mean. That's what they were trying to pull out. She's like, she's bigger than me. I mean, she's like twice my side. I didn't want this lady to beat my arse. I mean, come on. And she was like, well, what do you mean? I mean, she's security heavy. And then so basically, of course, that went around. That went around for a while. And I believe she had in her store, she had like a shirt or something that said security heavy. So she was able to make, for our, and that is the truth. When he said something about she went there for some type of, well, it don't necessarily mean it was an STD though. I mean, she could have just been having something going on. When he kept talking about some discharge, I'm like, sir, come on now. Yeah, could protect the, I mean, big enough to protect the building. It was because you cannot make this up. Like, she didn't know what his questions were going to be. I'm sure her attorneys couldn't prepare her for the shenanigans that was going to happen. So there were no indications. So it really was her responding to some of these questions that just seemed ridiculous and in the Cardi B way. So yeah. Dad said Cardi's just naturally funny with her heavy Bronx accent. She is. She definitely is. Yes, please hit that like button. Thank you so much, Chi Town. We appreciate you over there. All right, we're almost finished. Attempts to bias the jury are misconduct. He just coming up with all these reasons why there. I think there might be an order to show cause that's gonna happen, and it'll probably be televised. So we probably it'll probably be recorded, and we'll probably hopefully be able to watch and see what happens. Maybe we'll see. Attempts to appeal to the prejudice, passions, or sympathy of the jury are misconduct. And they have the case law Stone v. Foster and Martinez. Nor may counsel argue for jurors relying on subjective or sympathetic judgment or over an impartial judgment on the evidence. Yet, in closing, Mr. Rosen argued to the jury, for example, that he could imagine plaintiff's embarrassment and emotions. That plaintiff should be respected for her position as a security guard. That expert witness Dr. Rosenberg was, quote, hired gun who makes millions of dollars. I mean, we kind of do say that. So I don't know about that one though. But I'm feeling you on the rest of it. But the whole, it is the truth. Like, they do get hired to basically support your position. There are certain doctors that the bulk of their money that they make is from them to being a expert testifier, and that's their job. So I don't know about that one. That's a little borderline. And alluding to plaintiff's alleged emotional injury as a woman from a supposed scar on her face. It's cutting a little close to, because I mean, as an attorney, you can't say how it affected her. And she said that herself. She said it was, it affected her emotionally and how she felt. And apparently, I believe one of her family members talked about how she was a person that cared about how she looked. And so that really bothered her. It almost painted her a little vain. So it bothered her. So I don't necessarily believe. I mean, they just want to just hammer this down. They putting everything they can put in here. Mr. Rosen's appeal to passion rhetoric constitute additional trial misconduct and further supports issuance of an order to show cause. So now they're going to go. So those are all the reasons why they said supports their position that there should be an order to show cause. And now these are the sanctions available to the courts. Mr. Rosen's choice to disregard the court's order in limine and argue facts outside the record after the court's express admonition not to do so implicates the court's contempt power. The court may issue an order to show cause directing Mr. Rosen to explain, if he can, why he should not be held in contempt under Code of Civil Procedures, Section 1209A5, 1211A, and 1218, or otherwise sanctioned under those statutory provisions. California Rules of Professional Conduct 3.4F and 8.4D, or the court's inherent power. On the finding of contempt, penal sanctions may include fines up to $1,000 per violation. When contempt stems from violation of court orders, the court may additionally order fees paid to the party initiating the contempt proceeding. Cardi B identifies at least 25 distinct violations by Mr. Rosen of the court's orders in limine. Order from the bench prohibiting arguments of facts not in evidence, and established principle as to proper and improper closing arguments. Mr. Rosen's misconduct were egregious, persistent, and included both calculated attempts to do an end run around the court's orders and unequivocal unequivocal misrepresentations of the evidence to the jury. Despite multiple sustained objections, warning, and admonitions, he persisted, made no efforts to mitigate, and continued the same misconduct through closing. Deterrence is necessary and appropriate. In conclusion, accordingly, Cardi B respectfully requests that this court issue an order directing Mr. Rosen to show cause as to why he should not be held in contempt and sanctioned for his trial misconduct. And that is what was filed a few days ago on behalf of Cardi B. That was the attorneys requesting an order to show cause, which would be another hearing, and that sanctions are warranted according to them. And there's that. And that is the latest on the Cardi B. We thought the Ellis situation was over, but no, it ain't over. They are going for everything. Whatever they say belongs to them, they are coming for it. And there's that. Let me see what else you talking about. The Busby Jay-Z. I have to look that up. God love Jones. I'll look at that up when I get off of here. Maybe that's something we go over tomorrow if there's something going in. But I'll definitely look that up. Thank you for reminding me. Let me write that down. I don't know if I'm going to. If something happens, I'll come live tomorrow. But I have a long, busy day tomorrow. I have depositions and all type of stuff. So yeah. hmm Kelly said there was so much to put in this order. Yeah, it's a lot to put in the request. I love her and Nicki Minaj because my kids are from Queens. I just want them to get along and stop the nonsense. I don't know if that's going to happen in this lifetime, but we appreciate your kumbaya request. But I don't think it's going to happen. Have you guys been seeing all the drama all over the internet? Have you guys saw? I mean, and Cardi will let you know. She is about that life when it came to arguing with you on the internet. She has nothing but time. She's probably hungry and she's tired while she's pregnant. And she is letting everyone have it. People were saying she was afraid to go back and forth. You see who she didn't talk about was Nikki. You know, she ain't say nothing about Nikki. Well, that back and forth for 2-3 days were just, it was unbelievable. Unreal. You said, I am glad that you are sharing your perspective. The plaintiff's lawyer was wild. He was interesting. Not you called her Big Bone Brenda. That's not nice. That's not nice. But that's what they say. It's like, can bones really be big? I remember asking that question. Why do they call people big boned? Hmm. Can bones really be big? No, they can't. Anatomically, no, they can't. So anyway, that's it, y'all. If you guys care, first of all, hit that like button and subscribe if you haven't done so already. It's my second time coming on today. Welcome to all the people that come back to the replay. Okay. But Sean Diddy Holmes has been requested to go to Fort Dix over there in New Jersey in order to do his time in that facility because I guess they have a good RDAT program, which is the drug program. So that is even more time that would be taken off while people are concerned about his time. Let me see. Then there was also something they were asking again about they were asking Trump again about pardoning. They were asking about Ghislaine Maxwell. He was like, I don't know. I haven't looked in the facts. I have a lot of people that want to pardon. That's some power. You got all these people like, can you please just sign your name here? He could literally sign a document and get folks out of prison, out of federal prison. But let me see here. And then he said, everyone's asking me for a pardon. Puffy, that's what I call him. He's asking for a pardon too. Let me see what time you get offered that the RDAP program. RDAP inmates who are sentenced to 37 months or more can receive 12 months off for their sentence. So when we look at this, I already told people I thought he would get out by about next year sometime, and some people were like, "Oh no, that's not going to happen." So if he gets into the RDAP program, that's a year off, guys. If he completes it, which he probably will because he has that personality where he's going to finish what he starts and he gets to go home. So if he has, already calculated the 50 months, and then you subtract the months 14 he's already done. So he's looking at about 2.5. Then you take the 12 months off for the RDAP. That's a whole nother year. That's 1.5. Then he's going to get 85% off of that 1 year. So when you have the 85% off of that 1 year, that's about 9-10 months anyway. And so, yeah, he's probably going to do about a year. I'm just saying. I said around this time next year he'll probably be out if he gets into RDAP. So drugs being a part of this actually helps him in a way because they have programs specifically for drugs. And if you complete the program, you can get time off of your sentence. You said 6 months halfway. Yeah, he may not even do all the year in prison. That's why I said even if he now I agree that using acquitted acts is improper based on that the sentencing guidelines and the amendment. Now I would agree that that's the interpretation. Now the backdoor way that they were able to get it in, that the judge said there was another rule that you can get it under, another provision you can get it under. I'm not sure about that, but if that's the case, it seems like amending it to not allow acquitted conduct would be like, what's the point? If you have another way to get it in, what's the point of amending it? So I could totally see him for that issue, but I don't see the point of doing it to try to get a less sentence. Like just go through the drug program because you need it. We heard all of the drugs in the like when they arrested you, it was pink powder up in that doggone uh hotel room, and you knew that you had a pending arrest. Okay, so sounds really, that's an addiction. And they also will probably give him mental health because it sounds like he has some mental health issues. Because a lot of people go to prison without PTSD and they leave with PTSD. Most leave with PTSD. So he allegedly has PTSD already. And he also suffered from depression. So because of that, they can go in and he can get help. So he's not gonna do that much time. You gonna blink and he gonna be coming out. I'm coming home. No, he's not gonna probably come out like the larger than life person. He's probably gonna come out looking real humble. That's what I think. I think he's gonna come with that. Gonna totally reinvent himself. He should do some prison reform. He's gonna go there. It's gonna be a lot of stuff he doesn't like. That like Todd Christie. Todd Christie out here doing it. Todd Christie is out here walking people out of jail with his little tight jogging suit on, walking people out of prison, doing his thing because he was able to go to prison. And even though he got favorable treatment, according to him, because he had money and he was able to pay people to do things for him. So his experience wasn't as bad as his wife, who was like, I followed the rules. They had two different experiences. He still is utilizing his public figure, his popularity, and his money to help with trying to reform the system and helping people that were eligible for certain credits, but they didn't have the intellect in order to actually submit it. Or they were trying to submit it and they were being denied for no reason and they weren't supposed to be, but they knew that they were barely spoke English or didn't know how to read and write, and they wasn't gonna know what to do. And their families didn't have money either. So they were, in his opinion, a lot of people were taken advantage of because they lacked the knowledge. And then you had a bunch of CEOs who dang near don't like their job and they're not getting paid what they should be paid. And so They don't really care. They just come to do their job and going home. They're not taking it personal. They're not looking at the people like they're human beings and treating them like human beings. And it's a lot of inhumane conditions. So if Puffy takes on that, I think somebody needs to do it statewide. It's a lot of people that do it federal wide because that's what Chrisley, and I get it. That's where he served the time at. But I think he can reinvent himself and come out, and there's that. Christine said, I feel he got off better than none. How is this? How Todd Christie walking them out like this? His tight little gray jogging suit on. Y'all think I'm playing? Let me go find it. Cause y'all think I've been making this stuff up. I'm not even being funny. I'm serious. Let me see. Mm, Let me see. Let me see. Okay, he had on tight khakis. My bad. It was the other guy that had on the jogging suit. So he had on the tight khakis. So yeah, he walking people out, That's all. But anyway, y'all have a good night. Make sure you click that like button and subscribe to the channel. I'm about to go eat. You guys have a good night. Hopefully I'll see you tomorrow. If not, maybe Wednesday. I don't know, but you'll see me one day this week, hopefully, if the Lord, enables and allows. But you all have a great night until then. Talk soon.